Good evening everyone. Welcome to our next video. Today we are going to deal with an important topic, that is the first topic in Indian polity and governance. So the topic, the constitution and the different types of constitution. So let's straight away get into it. We are going to learn about the fundamentals of polity. As you can see here, let's go to foundations of the constitution. Let's see the definition of the constitution first. Constitution is a document in which the faith and aspirations of the people are recorded, and the aspirations include justice, liberty, fraternity, and unity. Justice is the fairness in treatment, that is, no two individuals are different, and liberty is the freedom of expression of many things. Fraternity is the brotherhood that lies within and between us, and unity is the bond, the unity among us. Fraternity, I shall show you an image of fraternity when you search in the web. That is, people come together, they celebrate even if they are from different caste, creed, or religion. So that is one thing. And now let me show you the picture of our constitution. This is how the Constitution of India looks like. That is, if you want to read the Constitution, you can just go and click in this link, and this link will directly take you to the Constitution. So let's go to other features. So this particular document is called the Supreme Law of Land, and it enjoys special legal sanctity. So what does that mean? Supreme Law of Land means that any law made by the parliament will only come under the constitution. That is, any law should come within the framework of the constitution, and if doesn't happen like that, then that particular law shall be declared as null or void. So it also enjoys special legal sanctity, special position above any other law. That is, it is the supreme law, and it enjoys a very respectful position above any other law. That is the meaning of special legal sanctity. If you search special legal sanctity in the website, it would come like this. So that's all about that. And now another area, that is section 66A of Information Technology Act. What did it say? It said that if one uses one's electronic device to send messages which annoys the other person in the opposite end, then the sender shall be imprisoned for 3 years. Okay, so what is the problem with this law? Okay, when you send a message to the other person, if you're saying the truth, then sometimes the truth is always bitter and truth is always annoying. And if you are criminalizing this particular sending of messages, then you are criminalizing truth, and it is against the freedom of expression of the person. So that is the problem with this provision, that is, it is against the freedom of expression. That is article 19(1)(a), which is a fundamental right. Shreya Shinghal, who was a young lawyer, she gave a case against this particular provision in the Supreme Court. I shall show you who is Shreya Shinghal. As you can see here, this is Shreya Shinghal. She gave a case against this particular provision, and then the Supreme Court said that no, this is not right, and said that the particular provision is unconstitutional. That is, it doesn't come within the framework of the constitution and it violates the fundamental right. Then the particular provision was struck down. You can see that here, striking the section 66A of IT Act, the Shreya Shinghal case. You can just read it. Another feature of the constitution is that it demarcates the functions of 3 branches of government. What are the 3 branches of government? The legislature, which is the lawmaking body; the executive, which executes the law made by the legislature; and judiciary, which examines and scrutinizes the policies which are implemented by the executive and the law which are made by the parliament. So that is what our judiciary does. So you can see the relation between all these 3 are set by our constitution, and constitution has demarcated it. So I shall show you the pictures of executed. This is a Prime Minister, Mr. Narendra Modi, and you can see this is also a legislature. This is a parliament, and this is a judiciary. So I think that's clear. And now let's go to another provision. Constitution sets a relationship between the government and its citizens. So what is the relation? As you know, we all have some or the other fundamental right, and this fundamental right is provided to us by the constitution and it is implemented by the government. And when the constitution gives us fundamental rights, what do we have towards the constitution? We have some fundamental duties. So that is the relation between the citizens and the government that is set out by the constitution. So here we end the lecture about our constitution. Now let's go to the different types of constitution. So there are, as you know, there are different types of constitution like written and unwritten, enacted and evolved, and federal and unitary. So let us first of all go to written and unwritten one. In the case of written, every law will be written in a single document, in a book-like structure. And in unwritten constitution, not all laws are written and all the written ones are not codified, that is not put together. For example, US and India have a written constitution, and that of UK and New Zealand have a unwritten constitution. Coming to the second point, that is written constitution can be tangibly assessed. That means you can access the particular written constitution. That is, if it is in the form, it can be in the form of a book. That is, you can read the particular whole constitution by taking it into your hand. That is, it can be tangibly assessed. But in the case of unwritten constitution, it is not like that. As it is not codified into a single document, you cannot tangibly assess. For example, if you ask me to show you the constitution of UK, I shall show you a library in which there are a lot of law points, there are a lot of books, there are a lot of commentaries which are part of the UK constitution. So that is a difference. The third point is written constitution are clearly codified into different parts and divided into different parts. That is, in case of Indian constitution, the part 1 is union and territories, part 2 is citizenship, part 3 is fundamental rights. I shall show you that. Here it is. You can see part 2 is citizenship, part 3 is fundamental rights, part 4 is directive principles of state policy, and part 4a, that is fundamental duties. That is, they are written and codified and divided clearly. But in the case of unwritten constitution, they are not codified and divided into particular parts. So that is a difference. And the fourth point is, in written constitutions, conventions do not play a very important role. So let us see what is a convention. A convention is a regularly observed practice considered appropriate for a given set of circumstances. That is a regularly observed practice. That is, no one needs to say that this needs to be done, or no one needs to write it. It is practiced for a long time that it has become a convention. In case of written constitution, as everything is written, convention need not play an important role. But in case of unwritten constitution, conventions play an important role because it's not written. In case of UK, the conventions play an important role. And the example is, any law passed by the parliament will be signed by the Queen. This is a queen, the present Queen of England. You can see here. And another convention is, the Queen will dissolve the Council of Ministers only after the advice of Prime Minister. The present Prime Minister of England is Miss Theresa May. If the Queen of England has to dissolve the Parliament, then she shall only do it after seeking the advice of Miss Theresa May. So that is another convention. It's not written anywhere, but it is followed. Another point is the judiciary. It plays a very important role when compared to other two branches of government. That is, judiciary is the guardian of the constitution, and it strikes down any law or any policy implemented which doesn't fall within the framework of the constitution. So judiciary plays a very important role. But in case of countries with unwritten constitution, that is parliament is very supreme. That is, parliament can make any law and judiciary doesn't have very much power over it. That is, in the words of D. Hume, who is English parliament can do anything except converting a man into a woman and vice versa. So you can imagine the power of the parliament. So that is what is explained. So we come to an end of that particular portion. Let us go to the second one, that is enacted and evolved. So what is an enacted one? In case of an enacted one, it is like a specific body is appointed to frame the constitution. That is, we constitute a body and then that particular body frames the constitution. For example, Constituent Assembly in the case of India, that is Constituent Assembly was appointed in the case of India. You can see this is the cabinet mission, and then this is the Constituent Assembly in case of India. You can see Jawaharlal Nehru here. But what in case of evolved constitution? It is a type of constitution in which no specific body is appointed to frame the constitution, and it is evolved over a period of time. We shall see two examples. Written constitutions are enacted ones and unwritten constitutions are evolved ones. As you can see, when it is written, it will be written and it will be codified, and many people will have to come together in order to do that. In case of unwritten constitutions, it evolved over a period of time. So that is a difference. So let's see two cases. First, we shall see the case of USA. So USA is an enacted constitution. US was a colony of British. They wanted independence from British. That is, 13 US colonies were the first part of United States, and they made an independence movement. The independence movement in America broke out and they declared themselves independent. These 13 colonies declared themselves independent. These are the picture representing the representatives of all these 13 colonies. You can see the US type flag here. So these 13 colonies thought of coming together based on their interest and frame a constitution. That is, they came together to enact a constitution. They met at Philadelphia, famously known as Philadelphia Convention. So this is the picture of Philadelphia Convention. And the first federal constitution of the world came into existence in 1789. These are the 13 colonies, as you can see here. See, these are the first 13 colonies in USA which came together. Then only the rest of them formed. You can see here, you can read. Now coming to the case of England. In 1215, Magna Carta was evolved. That is, it said that no free man shall be imprisoned and church will be separate from the policies. And over a time, many improvements came. This is Magna Carta. You can read it in detail. And this is how Magna Carta looks like. Many improvements came, like the Bill of Rights, Human Rights Act, and that is, these laws did not came at once. They evolved. They just evolved over a period of time. So that is commentaries. Let us know what are commentaries. Commentaries are the point of view published by important legal personalities. Commentaries are not an important part of enacted constitution, but are very important part of evolved constitution. In case of enacted constitutions, all the laws come at one point of time. There is no relevance in publishing laws late. So let's see what is federal and unitary constitution. In case of federal constitution, there is always a separation of power between the center and the states. But when it comes to the unitary constitution, all powers are concentrated in the center. There is no separation of power between the center and the states. That is, the classic example is US, which is a federal constitution, and in case of unitary constitution, that is England and South Africa, which are unitary constitution where there is no separation of. Another thing about federal constitution is more political power exists outside the central government. than when compared to the unitary constitution, that is with the state governments. But in case of unitary constitution, very less political power is there with the outside government and more exists with the central. In case of federal constitution, the local government are established and cannot be abolished by the center without a specific reason. But in case of the unitary constitution, smaller governments are established by center for purely for administrative purpose. That is, for example, England is a large country and state government will be established at particular smaller states for administrative purpose and not for any other purpose, and they shall be abolished or the power shall be snatched back whenever the center wishes to. Another point is that the powers of the governing system are not uniformly applied and have, that is, the state have their own discretion. That is, the state can decide whether this law is to be as such implemented in the state or not, or has there to be any other provision which need to be added according to the diversity of the state. So that is one provision. And the powers of the governing system in case of unitary government are uniformly applied and the state do not have a discretion. So that is another point. And when the decisions concerning the state are taken by the state government as implied in the previous point. For example, we have a state list here. The state list concerns of subjects on which the state have exclusive right to take decisions. So that is one thing. The state shall have its own rights and decisions. And but in case of a unitary government, every major decision is taken by the central government and the state government does not have any say. So that was about unitary and federal constitution. Let us understand 5 tests to decide whether a particular government is federal or unitary. So the distribution of power, that is, there will be a clear-cut distribution of power between the center and the states in case of a federal government, and it involves dual government, one at the center and one at the state. For example, in case of India, we have a central government and we have a state government. That is, we are a federal country. They will have a written constitution. Because written constitution is the only one which clearly separates the power. And until unless you know that where are the powers separated, you cannot really have a separation of powers. If there is not a clear-cut written constitution, then at any time the central government can snatch away the powers from the state government and it shall result in a unitary form of government. And supremacy of the constitution is the third point. The constitution should be abiding by both center as well as the state. Then the center cannot snatch the powers from the state. Then rigidity of the constitution, that is, the change in constitution must be a joint act of both center as well as the state. That is, we have union list, state list and concurrent list. That is the changes in concurrent list. And that is, if constitution need to be changed, the center cannot take the sole decision. They have to consult the state also. That is another thing. And independence of judiciary. This judiciary is the protector and guardian of the constitution. And if the state or central government violates the constitution, that particular law shall be declared unconstitutional. So this was about our video for today. So that is, we learned a lot of things: definition of constitution, other features, which is supreme law of land, special legal sanctity, problem with the provision, Shreya Singhal case, and constitution and the way it demarcates the functions between 3 branches of government, constitution and its relationship between government and citizens, and different types of constitution: written, unwritten, enacted, evolved, and federal and unitary. And then we came to the 5 tests that is to be conducted to understand whether a particular government is federal or unitary, and these are the characteristics of a federal government. Thank you for watching our video. Thank you, we love you. Wait for our next video and do the maximum you can for the betterment of the world. Thank you.